Today we've got emotional distress. Hi, I'm attorney Jill Ruane. In today's class in 2-Minute Law School, we are talking about the difference between negligent infliction of emotional distress and intentional infliction of emotional distress. Let's contrast negligent infliction of emotional distress, or NIED, with intentional infliction of emotional distress, or IIED. While both involve emotional harm, they are very different in terms of how the harm is caused and how the law handles them. Let's start with NIED. NIED happens when someone causes emotional harm through carelessness or negligence, even though they didn't mean to harm the person emotionally. In NIED cases, the focus is on the fact that the person acted without proper care and their careless actions caused emotional distress. There are 4 elements of NIED. First, the duty of care. The defendant had a duty to act carefully to avoid causing harm. Second, breach of duty. The defendant failed to meet that duty. They were careless. Third, causation. The breach of duty caused emotional harm. Fourth, damages. The emotional distress must be serious, not just minor stress or upset, which caused the plaintiff to incur damages. So, if a car almost hits a pedestrian, causing that pedestrian to feel extreme fear and emotional distress, for which the pedestrian experiences anxiety and misses that day of work, that's NIED. The driver wasn't trying to scare the pedestrian, but their carelessness created a situation that caused emotional harm to the plaintiff, causing them to miss work and incur damages. Now, let's talk about intentional infliction of emotional distress, or IIED. IIED, on the other hand, happens when someone intentionally causes emotional harm through extreme and outrageous behavior. In IIED, the defendant's actions are done on purpose, and they are so extreme that they would cause emotional distress to any reasonable person. Here we also have 4 elements that must be met. First, intentional or reckless conduct. The defendant acted with the intent to cause emotional distress or knew their actions would likely cause it. Second, extreme and outrageous conduct. The defendant's behavior was so shocking and intolerable that it goes beyond the bounds of acceptable behavior. Third, causation. The defendant's conduct directly caused the emotional harm. And fourth, damages. That emotional harm must be severe, not just minor stress or discomfort, which caused the plaintiff to incur damages. We'll dive a little deeper into some of these topics in future classes. Class dismissed. But first, if you wish you went to law school, or you just want to be smarter and win that next argument with your friends, be sure to hit that subscribe button and ring that bell so you can get new classes when they drop.